I'm Jeffrey Buss with Smith, Buss & Jacobs, lawyers here in Westchester County. We are having today a socially distant conversation with the Honorable Linda Jamieson, Justice of the Supreme Court, State of New York, here in Westchester County. And Justice Jamieson is assigned to the Commercial Division of the Court, which is the business court for Westchester County. Good morning, Your Honor.
Good morning. Nice to be here, Jeff.
Thank you for joining us. It's our pleasure.
Always.
I wanted to take this opportunity to acquaint business owners with the Commercial Division of the Court. It is the place where business disputes can be resolved in Westchester County. And the court limits the types of cases that it hears to civil disputes in excess of $100,000. They would often involve a breach of contract or a breach of fiduciary duty, a shareholder dispute, or some other purely commercial business type of dispute. And I don't know, are there other types of cases, Your Honor, that you...
Well, there are legal and accountant malpractice if it's relating to a business transaction. So those type of cases do come in front of us. There's also insurance cases to determine whether or not there's insurance. Those are going to be flooding our courts, I'm sure, soon. There's shareholders, derivatives. Of course, there is no monetary number on that one. But any case that involves a business tort definitely is in us. And as I call them, business divorces. Okay, a lot of business divorces. So breakup of partnerships or dissolutions of corporations, partnerships, limited liability corporations. All of those type of cases come before the court.
And, Your Honor, how has the court been handling the recent COVID situation?
Well, we've been doing all our conferences by Skype for business, which is what's been the official avenue in which to do conferences in the court system. We're going to be transitioning very soon over to Microsoft Teams, and I think that'll be a little bit easier for us. We are having hearings, preliminary injunction hearings, any other kind of hearing we will have in the courthouse, but it's limited to the amount of people that you can allow into the courtroom. I have limited my courtroom to 8 people. That's the only way I can socially distance everybody. We have everybody sitting in different areas, and we have, of course, face masks, we have shields, we have everything, and we have it sanitized. So that's what we've been doing, but I would say the lion's share of the work has been online, including mediation that we send people to, which we're going to talk about.
Well, I'm glad you brought up mediation. One of the topics I thought might be of interest for the viewers, many times, particularly as a practicing attorney, when we draft contracts for clients, there is a discussion about where a case should be heard or whether the case should go to arbitration. And in the last few decades, there's been a very strong push in favor of arbitration over courts. And in my practice, I actually have been pushing people to go to court now rather than arbitration. And I don't know if that impacts the volume of cases that Your Honor has, but...
Okay, well, let me explain the background of why everybody put in arbitration clauses, because the court system used to be so backed up. And it took years and years for litigants to get before the judge and have their day in court. But that's not the case now. We are up to date. You can get a trial within 6 to 7 months in the commercial division. We push our cases very quickly, and that's when the commercial division was specifically set up. It was to accommodate all the business actions that go on. New York City, New York is the epicenter of commercial transactions. So they devised the commercial division, which has its own separate rules that are different and distinct from the other civil parts. And specific judges who have the expertise in the area are assigned to those particular commercial divisions. In Westchester County, we have 2 judges sitting there, myself and Judge Gretchen Walsh. And that's all we hear is commercial cases, and we have expertise in that, and we move our cases very quickly. So we suggest to you, and we welcome it because that's what we're there for, to help the public. If you put clauses in, then it'll go to the commercial division. Then you won't be in arbitration because arbitration has become extremely costly.
Very, very
Yes.
costly. So, but one of the things about putting in a clause in a contract of where the case goes, I smile at this because you're not supposed to try to pick who the case goes before, but if you specify the commercial division, whether it's Westchester County or another county, um, there are a limited number of judges in those commercial parts. And so you generally have an idea. Here in Westchester, there's two judges, Judge Walsh and Judge Jamieson. And in New York County, there are a few more, but it's still a very limited and kind of discrete number. The judges that are assigned to those parts are very knowledgeable about business and the laws that impact commercial cases. As you had just had Judge Jamieson explain, they've made a real effort in those parts to speed up the process. So one of the original reasons people would go to arbitration is they wanted a quick resolution. And I found that you can actually get a very quick resolution in the commercial part.
Well, and we also have newly implemented, the end of December of last year, is presumptive mediation. We always had a mediation program within the court system, in the commercial division, but now throughout our whole court system, there is presumptive mediation, which means that there is going to be mediation. Presumptively, you're going to it. And we have a roster of people that qualify to be on the commercial division mediation panel, a roster of very, very terrific mediators. They have to go for approximately, I think it's 40 hours of training, 24 hours in general mediation, but 16 specifically in business, commercial division type cases. And that roster you can pick upon, when the attorneys come into the court, the first thing I'm pushing is to try to mediate it, see if we can avoid the unnecessary costs of litigation that just skyrocket. So the program allows for an hour and a half of free mediation, and thereafter it's approximately $350, $400 an hour. So that's reasonable. And as an attorney, it's a great program to draw upon, and you can narrow issues. Whether or not you resolve your own case may not happen, but you certainly can narrow the issues and see what the parties really are arguing over, and if we can, bridge the gap, I will come in afterwards and help. But mandatory mediation, as I call it, it's called presumptive in the courthouse, has been a wonderful tool for all the litigants as well as the attorneys and the court system.
That's a very useful function to have that independent, trained mediator step in early in a case so that things do not spiral out of control. And the one area that Her Honor mentioned, cost, for those of you who have not had the pleasure of being sued yet, you're probably not in business, but but those of you that have been there know that the costs mount very quickly. And unlike the types of investments that you would normally make in a business where you're looking at your rate of return, here you're kind of looking at your rate of expense without any guarantee of what the return might be. But I found that arbitration, when you go to the major arbiter forums, they charge fees based on the amount of your dispute as a filing fee.
Right.
And they can be very, very sizable. You file a case in the Supreme Court, it could cost you $300 in filing fees roughly to get started. In arbitration, you can spend tens of thousands of dollars on the filing fees, and then you have the fees not only for your attorney, but also for the arbitrator. And they generally range in New York from $500 to $1,000 an hour. Sometimes you see arbitration clauses that specify 3 arbitrators, so
Right.
you have to triple that. And then if you stop and think about it, when I appear in court and I argue a case for a client, Her Honor is employed by the state of New York, and nobody's paying the judge by the hour. But in an arbitration, you're paying the judge, both sides, you share the fee generally, but you're paying by the hour for the arbitrator to read your papers, to listen to your arguments, to think about your arguments, to write up a decision, and then to issue a decision. And I've had arbitrations where people have spent 6 figures very quickly on fees and arbitrator costs. So Courts are actually less expensive and just as fast.
Most of the courts, not all of them, and sometimes, I'm not gonna put down arbitrators, because that's a great avenue. If you're representing a client that has a significant amount of money to spend, and there's a lot of money involved, sometimes arbitration is the way to go, because you will get one person just spending all of his or her time on your case, whereas the judge has, I have 80 cases pending, so at any given time, maybe even more. Sometimes 100 cases, sometimes, depending upon where the basket is. Right now, I think we're going to be seeing a lot more cases coming in light of what's going on with COVID and businesses failing. And I ask everybody, when they come in and they have issues going, there's not a lot of money now. So mediation is really something that you need to be putting your effort into, and be prepared to mediate. Don't just do it as something that you just, it's an obligation, so I'm going to go through it. Be substantially involved in it, and do it with good faith, because what that mediator recommends is generally where the case is going to play out. I see mediation as being a very helpful reality check on a lot of things, because one person may be over here, the other here, and the mediator is going to say, well, this is the box of reason, this is where it's going to fall. And the two of you can make the decision, or the court can make the decision. I always say it's better for the two of you to make the decision. It's your lives. And I'm just talking, when I say two of you, it's usually two partners breaking up or something like that. But it could be more people involved. But if they make the decision for their lives, and how the case is going to play out, it's a lot better, because it's harder for people to I guess, stomach or swallow, a judge saying X, Y, Z. Nobody's going to be happy. But in a situation where you can mediate it and resolve it yourself, it's always the better avenue.
Do you have a philosophy, Your Honor, that you kind of employ sometimes when you start with a new case, what it is you like to see or hear from the parties?
Well, obviously honesty is the most important thing. Even if you did something wrong, I'd rather hear it than find it out. Because if I have all the facts in front of me, I can basically say where this case is going to play out. I don't want to say I'm predisposed, but I've been doing this for 40 years. And you basically know where the case will fall out. We have some very good commercial litigators. They're the top-notch in Westchester. You yourself are one of them. And they know that stuff too. So, sometimes attorneys don't tell their client, or they can't tell their client because of their relationship. They can't tell them what they don't want to hear. But I can tell them that. So it makes it easier for the attorneys. I'm there. I am a public servant. I'm there to serve you. I'm there to help you. I'm there to resolve the issue. So, if you need help, if an attorney needs help with their client, just call upon me. I'm there.
Have you seen a rise in any particular types of cases in the last couple of months?
Well, the last couple, I have had a lot of employment restrictive covenant breaches, because people have been, forced to leave a business, and then there's restrictive covenants that have been in place, so they've not been able to work in the industry, which is a problem to start with, because we are in a really down spiral. Also, partnerships are breaking up. There's not the money that they had. There's been a lot of problems in holding out as long as they can. But I try to, piece them back together if we can, get through this terrible time for everyone. Economically, I think if we can ride it out, it'll be fine. It'll come back full force. Waiting for that vaccine.
Okay. Your Honor, do you have a lot of women that appear as in front of you as executives or as attorneys? Or?
Not as many as I would like. It has not been in a field, and Jeff, you and I have spoken about this. It's not been a field that women have gravitated to over the years, I think. And I'm hopeful that it continues, that I do see an uptick in it. Also, many of the big firms, they're all the white shoe firms, and they would have their seniors go in and argue things, and most of the seniors are old men. So we, in the commercial division, we actually encourage people to have their young female associates argue the motions, because and then we'll give you an opportunity to be heard. I'll listen, I'll say, okay, I'll hear your motion on an oral argument where I might not have done that. So we are encouraging it because we do want the women to be more involved. But as it's not been a traditional role for women, but I'm hopeful because, they can solve cases just as well as any other person can. Man can. But you notice there's 2 women in the commercial division. That's all. That's all I say.
Your Honor, we have this tremendous judicial system here in the United States, but is it always the best idea to run to court and fight there?
No, I think it's the worst idea.
Mm-hmm.
I mean, obviously, you're airing your laundry in the public. It is public. It's not just, we do have confidentiality agreements that are sometimes signed, but once you're in court, it is a public arena. So everybody is seeing the laundry aired. And I said before, if you have to work hard at resolving it between the parties and the shareholders and the litigants, they should do it the best that they can among themselves, because once you are in the court system, it's not your life. You don't control it. The court is controlling it. So for me, although I'm there for you and I welcome it, sometimes it's necessary to come to court because nobody is agreeing, and one partner or one individual is doing something that's illegal and you want it stopped, or somebody's trying to throw a commercial tenant out and there's issues beyond non-payment of rent. Those are the cases I get. So a lot of times the cases that come in will come in preliminarily. They'll come in for an immediate emergency situation, and then the court will take a look at it, stop what's going on, more or less keep the status quo if necessary, or stop one individual from doing something that's totally illegal or really in contravention of what the corporate shareholders all agreed to. Then it's important for everybody to get to that table and work it out amongst themselves. I mean, because if the court's going to do it, again, I'll say to you,
Right.
It may not be what anyone wants.
Well, unfortunately, many times in business and in life, nobody wants to make a decision, and
They
that's
leave
what
it. They leave it to the.
they leave it to the judge, and you do that every day.
Right.
You make a decision.
Right, I do.
Um,
Yes, but also, as a judge, I encourage people to make the decision for themselves, because that's empowering to them. If you leave the decision up to the court, you've lost all power. So that's part of my philosophy when I deal with people that come in front of me, that I try to get the power back to them. I don't need it. Trust me, I don't need it.
Yeah.
But it's important for them to understand that they can formulate a resolution. There are some things I cannot do. They're just not legally, within my within my power. But the parties can do it. They can agree to things that I can't do.
But if the parties reach some sort of creative solution, you can make it into an order.
Yes,
so that
I could so order it. Yes.
and then it has the force of law.
Yes, of
or
course.
a binding contract.
Yes, of course.
So, Judge Linda Jamieson, thank you so much for being with us today and having this socially distant conversation. This is Jeffrey Buss from Smith, Buss & Jacobs. We look forward to seeing you again soon. Thank you.